When I printed it out, they had coded it to a metric reference to a firearm. But I took an extra page and I wrote blank on it. So even if they got the firearm, it wasn't loaded. District of Columbia, U.S. District Court, United States versus Michael Flynn, case number 1:17-CR-00232. Request for preserving claim of error. Request for preserving claim of error per Federal Rules of Evidence Rule 103 in U.S. versus Flynn, case number 1:17-CR-00232, District of Columbia, U.S. District Court, is hereby submitted by Charity Colleen Krause. While not currently a disclosed litigant in this case directly, Krause contends that efforts to interfere with her rights to due process in pursuit of efforts to engage the judicial system beginning officially on June 6, 2017, via other cases, provide ample evidence that 1. The name association of Judge Emmett Sullivan in Michael Flynn's case is connected to accusations that predate the date of filing of charges concerning Flynn regarding a, quote, pattern of racketeering activity, end quote, which were filed on July 20th, 2017, and itself was a refiling of a petition in the Texas Court of Criminal Appeals after the denial of a civil petition for, quote, lack of jurisdiction, end quote. Flynn's association with the charges, or rather matters connected to the charges concerning Flynn, was first identified on or around September 4th, 2017, within 1 week of implementation of updates to Texas laws concerning business licenses. The evidence was present on site at 920 Colorado Street, Austin, Texas, in the computer in the lobby that presented the updates to Texas licensing laws. 2. The state of Texas and members of all three state branches of government, as well as federal legislators and members of the federal judiciary from Texas, have obstructed efforts to submit charges in and an associated case involving a long-term investigation that itself is connected to allegations levied against Flynn, but that predate events or was concurrent to events alleged to be committed by Flynn or in regards to the charges directly associated with Flynn. 3. That as of March 5th, 2020 at 1:16 p.m. Central Standard Time, the docket for United States versus Flynn, case number 1:17-CR-00232, demonstrates manipulation of the filing process and the electronic filing process that is itself evidentiary of the original allegations of a, quote, pattern of racketeering activity, end quote. 4. That as of March 5th, 2020, it has been more than 21 months since the Texas Board of Insurance Commissioners, specifically under the direction of Director Kent Sullivan, was requested to open an investigation into allegations of insurance fraud that had national security implications, as well as was requested in connection with allegations of, quote, large-scale securities fraud, end quote, that went back to original efforts to report officially to local law enforcement in Houston, Texas, as early as December 10, 2016 and onward. Hence, the state of Texas, per its own rules specific to the jurisdictional consideration under the rules of the Texas Insurance Commission, is in default on its obligations to provide a formal report in response to a formal request for comprehensive investigation attendant with a hearing requested in July of 2018. 5. Evidence of the original request for investigation of activities in connection with a request to the Texas Insurance Commission has resulted in kickbacks in the form of acts of fraud involving both the Texas Insurance Commission as well as unconstitutional efforts of members of the Texas legislature to change laws so as to obstruct disclosure or due diligence in accordance with adherence to the Bill of Rights of the Texas Constitution in connection with these allegations. 6. That these legal changes in Texas were intentionally coordinated to engage acts of, quote, fraud, end quote, connected to insurance and pension systems. 7. That the ramifications of these acts of fraud are severe enough to potentially and demonstrably jeopardize national security. 8. That the case regarding Flynn is connected to illegal and unconstitutional abuse of the judicial process via derivative litigation that is in violation of rights to due process, as well as in accordance with unconscionable acts that legally constitute torture. And 9, that failure to cease and desist with these manipulations of the constitutional system and to instead proliferate them effectively aid and abet the enemies of the United States of America and constitute a form of sedition severe enough to qualify as treason. On January 16, 2020, a petition was filed in the Northern District of Texas U.S. District Court as an effort for, quote, leave for motion to request new trial, end quote, in response to a denial of rights to due process in September of 2018, connected to an effort to intervene in consideration of updates to Texas laws that went into effect on September 1st, 2019, that were evidence of the herein mentioned, quote, pattern of racketeering activity, end quote. Following the denial of that petition, which itself is a follow-up to consistent efforts to formally report on matters via local and federal authorities going back to March of 2016, several events that compromised national security domestically were permitted to occur without appropriate intervention to interdict or prevent them, despite the fact that foreknowledge was available and that the means existed by which to do so. In the interim, members of the United States Senate passed a bill which itself constituted a further effort to materially aid and abet conditions that constituted national security threats. As such, 3 petitions were filed on January 16, 2020, one with the Supreme Court of the United States and 2 with the Northern District of Texas U.S. District Court. At this time, all of the petitions have been denied in manners which effectively demonstrate not only abuses of the judicial system, as well as abuses by the executive and legislative branches, but have also escalated the national security concerns attendant with these violations to acts of treason. At this time, an urgent request is made to refuse to issue any more opinions or verdicts that limit exercise of rights to due process, leveraging or counter-leveraging, quote, attorney-client privilege, end quote, and or that refuse to provide full disclosure of the matters under consideration. Additionally, a request is made to reassign the case out of the court of Judge Emmett Sullivan so as to preclude any further abuses of the judicial system in efforts to aid and abet an ongoing criminal conspiracy in the state of Texas and in connection with abuse of the system of redress available under the Texas Insurance Code via the Texas Board of Insurance Commissioners. Evidence is available to demonstrate how this criminal conspiracy is not isolated and in fact has been demonstrated to have occurred in a similar pattern within the last 20 years. Oath of attestation. I attest that I am of sound mind, a legal resident of Texas and citizen of the United States of America, am over the age of 18 years old, and that everything herein stated is the truth to the best of my ability. Signed, Charity Colleen Krause, 3:55 p.m. Eastern Standard Time, March 5th, 2020. Before 3:55 p.m. Central Standard Time, this was in the mail via the downtown Dallas post office. There was also a call to follow up. I spoke with both the bailiff and somebody representing themselves as the secretary of the judge.